So as attorneys, it's hard to stay on top of the law as it's constantly changing. And so I wanted to make a short little video and address a case that's being heard by the Supreme Court. They've already had oral arguments and we are waiting on a ruling. Arizona Court of Appeals Division 1 has heard this case and came out with kind of an interesting decision. It has to deal with the Juvenile Court Rules of Procedure, Rule 64C and Rule 65, C6C. The case is Trisha A v. Department of Child Safety, and the issue is regarding severance orders that come out of pre-adjudication hearings, the preliminary hearings that come before the actual termination hearing that's already scheduled. When parents don't show up to those hearings, DCS can ask for the hearing to be accelerated and to have a hearing on the issue of termination, and the judge can then terminate rights. Now, parents after the fact can turn around and request that the severance order be set aside. Typically, the court requires the parents to show that they had good cause for their absence and that they have a meritorious defense to the severance. However, this case, Trisha A argues that that is a heavy burden for the parents to have to carry because some of these preliminary hearings are months before the actual termination hearing, and sometimes parents don't have the ability to start using services, to start complying. They're still in the process of seeking the services and getting enrolled in the services, and so they've yet to have any time to actually build and establish a meritorious defense to the severance. So Trisha A's attorneys are asking that parents should only have to show good cause for their absence rather than also meritorious defense. Now, the appeals court ruled that the parents' rights are a lot stronger. Their interests are a lot stronger in these preliminary hearings than the state's interests because there's already a termination hearing set, so there's already a timeline going where the parents' rights, it's going to be decided whether the parents' rights are severed or not. And these preliminary hearings are just to deal with routine issues and making sure the case is going where it needs to go. Because of this, the state's interests are low because they're going to get where they're headed anyway, whether this hearing is accelerated or not, and that in most areas of law, it's not required that the client show up to every single hearing, even if it's just a 5 or 10 minute hearing. And so, therefore, the parents' interests are heavier than that of the state's. The parents' interests outweigh the state's interests in these cases, and because they come so far before the actual termination hearing, and often the attorney is equally as surprised as the courts about the parent's absence at the hearing, the attorney is then caught off guard, essentially, and is being thrown into having to make a case for why these parents who didn't show up should be able to keep their rights to their children without their client there to testify, and likely without really having time to have prepared for this type of hearing because it was supposed to be, could have been months down the road when it was scheduled, and now all of a sudden it's today. So they decide that the court should only require good cause for the parent's absence rather than a meritorious defense in these preliminary hearings, these hearings that are accelerated due to the parent's absence. They even go as far as to suggest maybe the court shouldn't be accelerating these hearings. Maybe they should just be waiving the parents' rights to attend that hearing rather than accelerating these hearings because the case is already on track to going to a termination hearing. So then we get to the Supreme Court, and I'm expecting Trisha A's attorneys to argue the similar findings of the appeals court that these preliminary hearings should be held to a different standard. Their severance order should be held to a different standard than that coming out of a termination hearing. That these severance orders coming out of these prelim hearings should be held to good cause shown for absence and not the meritorious defense. However, that's not what they argue. They argue that whether the severance orders coming out of the preliminary hearing or out of the termination hearing, and the parents were absent, all the parents would have to show is good cause for their absence and get the severance order set aside and a new termination hearing. And I think this was a fatal flaw in their argument. I think they would have been better off kind of going with the argument and the reasoning that the appeals court used about the parents' interest outweighing that of the state's in these preliminary hearings, and requesting that the court modify the standards in these preliminary hearings to just the parent showing good cause for their absence and allowing the case to go forward to the scheduled termination hearing. Not changing the standards when the severance order is coming out of the termination hearing. So you'd have your preliminary hearings. If parent's absence and they're accelerated, parent just has to show good cause and the case goes on to the termination hearing. However, if the parent's absent at the scheduled termination hearing, the parent would have to show good cause and a meritorious defense in order to set aside that severance order. But Trisha A argued that at preliminary hearings and at the termination hearing, if the parent's absent, they should only show good cause. Now, the thing about this case is Trisha A is not the perfect plaintiff for this case. I mean, she wasn't in the situation where this was kind of her first hearing and she really hadn't had time to start seeking services. She wasn't in that situation. She had been involved with DCS for over a year prior to the adjudication hearings getting started and hadn't complied. She had drug issues, she was sporadic with her contact with her children, so she was definitely not the perfect plaintiff. And then she doesn't show up to this hearing because she's enrolling into rehab. The rehab says she's checked in at 12. Her hearing was a couple hours prior to that. At first, she petitions the judge for this set aside and says, I was checking into rehab, I was trying to rehabilitate, I have good cause. Judge says, yes, granted. DCS comes back and goes, hold up. She was there. It says that she checked in several hours after the hearing. She's had plenty of time to check in. In fact, she only stayed for 2 days before she left against the treatment center's advice, and she can't establish a meritorious defense to her severance. So then the judge retracts his set aside and says, no, the severance order is in place. And it's kind of wishy-washy on whether he decided that because there was good cause or because she didn't establish a meritorious defense. But either way, the appeals court could have thrown this out pretty easily by just saying there wasn't any good cause for the absence. End of case. But they didn't. They went on to deal with whether this meritorious defense in preliminary hearing should be a requirement for parents or whether that's too heavy of a burden, because the goal is to keep as much due process intact in these hearings as we can, and so the court thought maybe that was too high of a burden, so they dealt with it. They decided it was too high of a burden in these preliminary hearings, and it's now at the Supreme Court, and we are waiting for the results to see if the Supreme Court agrees with the appeals court. Is it too high of a burden to request parents in these preliminary hearings to show good cause of their absence and a meritorious defense to the severance? Well, I guess we will wait and see, and I will update you when Arizona Supreme Court gives us an answer.